Morning, Your Honors. We're here, I forgot to tell you, I'm Charles McFarland. I represent Mr. Selgas. I'm from Kentucky. We're here today to correct a conviction that should have never legally or factually happened. Mr. Selgas was convicted of 2 criminal offenses: income tax evasion of the payment of taxes, and also the conspiracy under Section 371. I will primarily be addressing the evasion of the payment of taxes in today's argument because the 371 conspiracy rises and falls based on what happens with the evasion of the payment of taxes crime. Mr. Selgas was convicted of evasion of the payment of taxes for the years 1998 to 2002 and for the year 2005. Even though the taxes from 1998 to 2002 were fully paid, and the deposit was paid by Mr. Selgas for the year 2005. The taxes for the years 1998 to 2002 were paid by the chip data withholding, and the taxes for the 2005, Mr. Selgas made a deposit of $14,850 when he filed his return. And that was paid for by a deposit was made by a check that accompanied the return. And it was reported everything that was on his return. And because the prosecution was unable to prove a, quote, tax deficiency in this case, the charges against Mr. Selgas should be remanded. The reason for this is because had the tax deficiency been presented to the jury, they would have discovered that the payment of taxes from 1998 to 2002 was actually paid. He made a deposit for 2005, and the IRS failed to show follow the Internal Revenue Code for determining what the tax deficiency was. Had they had that information, it would have been a different verdict by the jury. I want to point out that the indictment was very, very specific. Thomas Selgas was charged in count 2 with evasion of the payment of taxes. Count 2, he specifically was charged with payment of taxes, failure to pay taxes, evasion that for the years 1998 and for the year 2005. So there were 2 periods of time that were involved in this. And because of this 2 periods of time, we have to look at the 2 different periods and what happened. The taxes from 1998 to 2002 were fully paid. I'm going to address that in a few minutes. But I wanted to start with 2005. Taxes for 2005 were not due and owing because the IRS did not follow the tax deficiency procedures.
But this whole trial was
Pardon?
Counsel, this whole trial went forward on the basis of a evasion of payment theory. An evasion of payment theory. Insofar as the trial, it was all about evasion. What I'm getting at in the constructive amendment argument is that the trial was conducted of a theory that goes forward. I'm going to give up. The difficulty is that you argue that the district court's instructed to be specific on count 2, constructively amended the indictment, correct?
I'm not sure I understand what your question was because I'm a little hard of hearing and you're not coming through as clear as I would like. So can you say that a little bit louder?
Well, I understand your argument that you rest on the difference in the language between the jury charge and the indictment.
Oh, that is one of the jury instructions, yes. And I think what you're talking about is that one of the jury instructions did, in fact, give a choice between evasion of the payment and failing to file. Is that what you're talking about? Well, in any event, the taxes for 2005 were not due and owing by Internal Revenue Code because in the Internal Revenue Code, tax deficiency does not happen until there is a tax return filed and a deposit made, and the IRS goes through the procedure of determining the tax deficiency. Once that tax deficiency is determined, it's a notice of deficiency is sent out, and it goes to tax court, or if the person doesn't pay, go to tax court. They send out a notice of deficiency or a notice of demand, and the tax is not due unknowing per law until that notice of demand is sent out. Mr. Selgas did pay his 2005 what he calculated as his tax and reported it, and I just want to make that clear. Anyhow, what's happened here is throughout the course of the legal actions on Section 72.1, almost all courts treat these two crimes as one crime. But the Sansone case made it clear there were two crimes. One is evasion of assessment, and one is evasion of the payment of taxes. And that's been recently decided in 2012. And the elements of crime are willfulness, tax deficiency, and an affirmative act. But Mr. Selgas was only charged with evasion of the payment of taxes, not the assessment. And the Fifth Circuit has never addressed that particular issue where somebody filed a return, made a deposit. So they've never addressed that particular issue. So this is the case of first impression. So the question is, what is a legal definition of tax deficiency, which is what the courts are supposed to follow. Tax deficiency is when somebody files a tax return and reports what they made and paid it. Then the IRS makes the determination based on that return that additional taxes are owed. That is a tax deficiency. But it does not become, yes.
That just sounds like a legal argument to me about what the definition of is, what the definition is for tax deficiency. And I guess I maybe misunderstood your claim, because I thought your claim one on a constructive amendment, you're claiming that there was an amendment constructively to an indictment because of the use of the language evasion of assessment and then evasion of payment.
No, that wasn't the constructive amendment I was talking about. The constructive amendment I was talking about was where the judge made an instruction that the jury could find him guilty of a felony or of a failure to pay. And my argument was addressed at what the definition of a tax deficiency was. Okay? And
so who misinterpreted or misread the definition of tax deficiency? Where did that error occur?
I would be saying that the courts misinterpreted what the tax deficiency was. Way back with Mr.
The district court did.
No, Sansone did. The Supreme Court. Sansone used tax deficiency, and in Sansone's case, there was no tax deficiency. There are three ways that you can have tax due and owing. One way is there's no tax return filed. Tax is due and owing on April 15th. The second way is when a person files a tax return and reports his taxes but doesn't pay it. That is also a tax due and owing. It's not a tax deficiency. The third way is what I've already explained, is when they determine there's a tax deficiency and they go through the tax court process, and after the notice of demand comes in, the law says that, I think it's under 6215 and 6213, the law says that the tax is not due until that notice of demand is sent. So there is a difference between a tax deficiency and a tax due and owing. And the Sansone case listed tax deficiency when it should have been saying tax due and owing in that case. And that's what I'm looking at here is the element of a tax deficiency only comes up when a person files a tax return and pays something, and then the IRS determines there is a tax deficiency. That's the only place in the code where a tax deficiency comes up.
Let me ask you a question about
Yes.
from 2007 to 2017, over a 10-year period.
Mm-hmm.
Your client deposited more than $857,000 into Green Lawyer trust account, their IOLT, the lawyers have to maintain for trade, such a trust fund. And they have paid all their expenses over a period of 10 years out of that. When they needed about that account.
Okay.
Can you
Well,
give me an explanation for that arrangement?
Yes, I can. The reason for that is...
Other than the obvious one.
Okay, first of all, on the IOTA situation, there's three reasons for why that IOTA account is there. First of all, the IRS never notified Mr. Selgas the 2019 or the 1998 to 2002 tax returns were due. They were paid by a tax return. It was filed. The IRS credited him in 2 years, well, immediately when he filed them in 2006. 2 years later, they reversed it and never sent him a notice about it. The second thing is, there was no notice ever sent to him about 2005. So the question about the IOTA is really kind of going off track here, because the IOTA, the IRS was saying he was trying to hide it from the IRS. But he didn't know he owed anything. And didn't have any notice he owed anything. What he did with the IOTA is basically immaterial. The second part of it is tax deficiency was not sent out on 2005. And the third issue is Mrs. Selgas testified earlier that Mr. Selgas had problems earlier with banks, and he didn't trust banks. And he discovered that in Texas, when an IOTA is used, the client is the one that owns the IOTA. But the Supreme Court in Shaw versus the United States, I believe it's the 2016 case, made it clear that when the person makes a deposit in the bank owns it. And it's kind of like a equity ownership of it, because they can loan his money out, so they own it. And he didn't trust the bank, so he put it in the IOTA. And that's the primary reason he did that. That didn't come out at the trial, except through Mrs. Selgas' testimony.
So he put money in an IOTA so the bank couldn't loan it out to somebody? Is that what you're saying?
Basically, yeah, because he wanted to own his own property, and he'd already lost some money years ago from the bank. He had borrowed some money from someplace, and the bank come in and closed out his account, and he lost money on it. That was one of the reasons why he did it. That never came up at the trial. But, and through his attorney, he found out he could put the money in the IOTA based on the bank, on the...
Is that the same reason that you got the transfer of residence in Athens, Texas, to the son-in-law in trust?
That is excuse me, I'm gonna say something, I hope you understand. That characterization is a bald-faced lie. That, not to you, but was said by the IRS. The trust was set up by the father-in-law, who paid the money into the trust. It was his own money. He paid for the trust.
But the effect of that essentially was to prevent the government from discovering the title to it. In fact, it did succeed in doing that.
No, it didn't. What happened was the IRS, first of all, the IRS did not have any legal reason to collect because they hadn't sent out any notice or anything. But the trust was paid for in gold coins, which was equivalent to over $300,000. It was paid for.
Another question. So a question not directed to the method of payment of your gold theory, except it is directed to the proposition that I'm sure the government argued to the jury that you're evading income taxes, to put it correctly, and that you have your resident, you put all your money with a lawyer and all the counsel, they don't know where it is, and you have a resident, you think you go over to buy a property in Athens, Texas, and then if they're in chain of title, well, then you put that in another trust. To get that out. I'm just saying to you that why is the jury reasonably conclude that this is we put the picture together, this is nothing but an effort to avoid income taxes.
Excuse me, the reason why the jury couldn't figure that out is because the government misrepresented that trust. That trust was not a nominal transfer. That trust, the father-in-law paid without money.
The effect of the trust was to prevent someone from looking at the chain of title, looking from the deed records, land propositions under Texas law, to foreclose it. That was the effect that it had on the government to locate that property.
No, the reason the trust is set up because Mr.
My
Selgas
question is
is
not whether a jury is reasonably able to conclude from that.
Well, they can
that they're
conclude-
paying income taxes.
they can conclude what you just said because that's what was misrepresented to them. The trust was not a nominal transfer. It was purchased outright. And it was purchased for the reason that Mr. Selgas was going through cancer treatment and needed money, so his father bought the trust for that. So
Did
he
you
bought it
argue
with Mr.
that
Selgas.
to the jury?
No, we didn't because we didn't have. I got involved in the case just before the trial started. Didn't know all of this, and the other attorney did. So I see my time is up.
Good morning. May it please the court, my name is Terri-Lei O'Malley, and I represent the government in this case. Although Mr. Selgas raises several issues, with the court's permission, I'd like to focus on his claim that the statute of limitations instruction was reversible plain error. In the statute of limitations instruction, the court refers to failure to file a return. However, that did not alter the elements of the tax evasion offense. It also did not change the government's prosecution and theory of the case. And it didn't change the outcome of the trial. As a result, a reasonable jury, properly instructed, would have convicted him for affirmative acts committed after July 18, 2012. And specifically, as you yourself have noted, Judge Higginbotham, the dozens and dozens of transfers in and out of Mr. Green's IOLTAs. On page 11 and 12 of the government's brief, there are two charts that show the yearly, and I'm fairly sure that you've seen that because you pulled the number from there. I can also point out that after the statute date, about 313 went in and 389 came out. Selgas' use of Green's IOLTAs is so incriminatory that he doesn't even discuss it in his briefs. Now, he also makes another claim of reversible plain error in the jury instructions, and that, I believe, Mr. McFarland has addressed more directly, and that is a passing reference to assessment in the actual evasion of payment jury instruction. Now, this court in Masada and Nolan made it clear tax evasion is a single offense that can be committed two different ways, by evading assessment or by evading payment. But once again, that passing reference in the jury instruction for tax evasion did not change the elements of the offense, it didn't change the government's case, and it didn't change the outcome of the case. There were numerous affirmative acts following the statute of limitations date, and not just the dozens and dozens of transfers in and out of Mr. Green's IOLTA accounts. There were also the gold-funded IRA that Mr. Selgas realized the government had found, the revenue officer, Daniel, had found a retirement account at Equity Trust. And when Mr. Selgas found out that the government was aware of that and that the government could levy it, he removed it. And he removed it prematurely, which everyone knows has severe tax consequences. But let me be clear, Mr. Selgas has not paid his taxes. He simply has not paid his taxes. He hasn't paid his full taxes since 1998. 97 was paid by the 14,000 something check that he sent in for his 2005 taxes, which should have been at least 10 times higher. Mr. Selgas hasn't paid his taxes. And not only has he not paid his taxes, he has made every effort possible to hide it from the government, to hide it from the IRS. And he has played this game with the IRS in different iterations for well over a decade. A decade was what he was putting his money in Green's IOLTA. The court properly instructed the jury on the elements of tax evasion, including the necessity for an affirmative act of evasion, and that Selgas was not on trial for any act, conduct, or offense not alleged in the indictment. The government did not allege failure to file at any point. Failure to file wasn't alleged as part of the evasion payment case. It was not alleged even as part of the conspiracy. In fact, the only...
Let me ask you a question. What was the total taxable income for which taxes were not paid?
Oh, goodness. From, I think, 2002 was primarily paid because there were withholdings that year. From 98 to 2001 was probably a couple of $100,000 income. But the big haul was the My Mill distribution in 2005. And that was approximately $1.3 million of income that Mr. Selgas did not report on a tax return. Now, he's going to claim that he did make a tax return, but he actually just filed a false statement with the government, with the IRS, substantially undervaluing that distribution.
And that statement wasn't a return, was it?
No, it was not a return. He claims it was what's called a beard return, which is basically something designed to determine whether the statute of limitations applies when you're attempting to determine whether the return was filed on time. The beard return is simply a way of allowing someone to file their return if they don't have access to the proper forms. His statement was not a return. It was not even a beard return. In fact, the statement shown at trial, the 2005 statement, wasn't even signed, much less signed under penalty of perjury. Had it been signed, and I do believe that there must be a version somewhere, this is a version the government got from Selgas. It must have been signed at one point because we know that the government deposited the check. But even had he signed the document that was entered into evidence, it was not signed under penalty of perjury. Those words did not appear. And it was not, in fact, Your Honor, a good faith effort to report his taxes to the IRS. I can address the other issues as well if Your Honor would like. If you have no further questions, then I will be happy to give my time back to you. The government asks that you affirm Mr. Selgas' conviction. Thank you.
Yes, Your Honor. I would specifically like to address very, very quickly on the trust. Mr. Selgas was given a life estate on it, and the trust was geared for the father-in-law's grandchildren. They would take over after his life estate. So it wasn't a purpose to hide anything. It was to pay his medical expenses. Second of all, I want to address the beard return. You probably asked me, why the beard return? Well, the beard return is authorized in the Fifth Circuit, and it has been followed by the Beard versus Commissioner, and there are certain requirements that have to be there. When Mr. Selgas filed his 2005 statement, he listed the requirements of the Beard Commissioner case in there, put them all in there, and he did sign it under perjury. The problem is when the IRS received that, they didn't process it. Their Internal Revenue Manual said they're supposed to process beard returns. They didn't process it, even though it was filed. They sent it to Ogden, and they got a copy that Mr. Selgas had that wasn't signed. It was his copy, but the original signature is someplace in Ogden, and it's in the possession of the IRS, and it was signed under penalties of perjury. And he listed all the requirements of the beard return, and his purpose of filing that beard return was not to evade taxes. He was challenging something that had nothing to do with taxes. He was challenging the Secretary of Treasury's requirements under Title 31, Section 5119, that he was supposed to keep the Federal Reserve notes and the gold concurrency in equal purchasing power. And he was trying to challenge that. And he actually paid, he took $1,850 or $485 gold coins. He actually tried to pay the IRS that. The IRS rejected it 7 times. That was in the transcript testified by John Green, who accompanied him with that. Then, when he calculated his taxes, he based it on the gold standard, and he came up with the $14,480. And he took that money to the bank and paid them that gold. And they only gave him a check for $14,850. But when you look at the last 2 pages of his return, he points out that he paid the bank in the same amount of gold that he started off to pay. So he paid $1 million or $600,000 in taxes, trying to pay to start off with. And then when he went to the bank, he told the bank, this is $1,485, and that's on his statement. That's what he did. The bank took it and only gave him a $14,000 check. Then he sent that to the IRS and told them to redeem it according to Title 12, Section 411, which the IRS didn't do. Instead, they wanted to charge him with failing to pay. So contrary to what the council's saying, he did pay his taxes. But the problem is the IRS never got it because of the quirk of the law, which is basically a situation where you've got, even today, in today's society, people are concerned about inflation. He was addressing that way back when, back in 2005. You take a $10 gold coin to the bank and they'll only give you a $10 bill, even though it's worth $500 today. And there's something wrong with that kind of a situation. And for somebody to be trying to point out the inequity in the law, to charge him with the evasion of taxes when he tried 7 different times to pay it in gold coins, and the IRS rejected it. The same thing happens in 1998 to 2002. He went to tax court, and this is the one thing that really is you should understand. The IRS said he was not allowed withholding because of the tax court. There's not a single tax court existence that says Tom Selgas was not allowed withholding. That was his wife. They called him a nominal tax petitioner. I never heard that term before. The new term. She was there individually, and they said she couldn't take the withholding. But when he went to court on his own, they said he could. So they're telling the jury he wasn't allowed withholding. That's why he didn't pay his taxes. So, unless you have any questions,